allegations as to things that have happened without very specific evidence that's being offered before the court. As a practical matter, through the jury selection process, the court has provided instructions, has determined whether or not there are any outside influences. The law presumes that the jury follows the judge's instructions, and the court has instructed the jury today that they're not to let any outside influences or public opinion sway their deliberation. And the law presumes that they will be capable of doing it. And so without any sort of specific offer of proof or information in the record, without any specific evidence that this particular jury was influenced in any particular way, I believe that the defendant's motion should be denied.
Your Honor, I make my comments, in the context of this is all such an evolving situation. Obviously, I spend my weekend preparing for closing remarks, and I certainly can supplement the record with news articles. I can supplement the record with the storylines of the particular shows that were brought to my attention. So I'm making it to note the record at this particular point, and I can certainly supplement.
Yeah, you can supplement the record with whatever media reports. I'm aware of the media reports. I'm aware that Congresswoman Waters was talking specifically about this trial and about the unacceptability of anything less than a murder conviction, and talk about being confrontational, but you can submit the press articles about that. This goes back to what I've been saying from the beginning. I wish elected officials would stop talking about this case, especially in a manner that is disrespectful to the rule of law and to the judicial branch and our function. I think if they want to give their opinions, they should do so in a respectful and in a manner that is consistent with their oath to the Constitution, to respect a co-equal branch of government. Their failure to do so, I think, is abhorrent, but I don't think it has prejudiced us with additional material that would prejudice this jury. They have been told not to watch the news. I trust they are following those instructions, and that there is not in any way a prejudice to the defendant beyond the articles that we're talking specifically about the facts of this case. A congresswoman's opinion really doesn't matter a whole lot. Anyway, so motion for mistrial is denied. With regard to, there was a report that counsel were made aware of a few days ago that a juror may have been talking to a major media outlet. We checked with that major, and it appeared right from the beginning that it was third-hand, hearsay, telephone game. That media outlet, in fact, took it very seriously, did a nationwide contact of all of its reporters and staff to check out any veracity, and there apparently is none whatsoever. Nobody from this major media outlet made any contact, and I find that credible. And so just for the record, I pass that along. Now, I think we still have the memorialization, but we also have to talk about a Blakely waiver.
Yes, Your Honor. So a couple of things. In terms of the memorialization of sidebars and the objections, we had previously provided, and we had suggested that we provided our memorandum of the objections that the defense had made at sidebars. I am going to propose, rather than just simply reading through and taking an hour's time, that we submit those objections in writing, now that happened, and in consultation with the state, and they can include their objections that we did not include.
It'd be nice to include just essentially a stipulated pleading that sets out what the objection was and what the court's ruling. There's no need to repeat what the arguments were. The only thing that you need to preserve for appeal is what the objection was and what the court's ruling was. So I would encourage both parties to get together and figure that out and file it reasonably quickly. It doesn't have to be today, tomorrow, or even the next day. But just to get on it while our memories are fresh.
And if there's a discrepancy between the memories, Your Honor, I'm expecting that we're going to be able to come up with a stipulated document. But if there's anything that needs to be set out, we can just indicate our contrary memories of that. It should be pretty simple.
Absolutely. I think that would be the best way to memorialize this in any case. All right. Other than Blakely, do we have any other issues to make a record of?
No, Your Honor, I think we just need to have some administrative discussions about questions, timing.
And we can do that in a chambers discussion. All right, with regard to Blakely.
Sure. I have not yet had Mr. Chauvin execute the written waiver. Again, I do have it. We can print it and get that taken care of. But I can do an oral waiver now if the court.
If you would.
So, Mr. Chauvin, you can take your mask off. Mr. Chauvin, you're aware that during the course of these proceedings, the state has filed what's called the Blakely Notice, or a notice to seek an aggravated sentence, correct?
Yes.
I have explained to you the bases on which the state is seeking to have an aggravated sentence imposed in the event of a conviction on any one of the counts here, correct?
Correct.
We've discussed those, and I have specifically advised you that you have a right to have a jury decide whether or not the state has proven those grounds for an aggravated sentence beyond a reasonable doubt. You have the right to have a jury decide if you violate it, right?
Correct.
And I've advised you that the state has to prove those grounds beyond a reasonable doubt.
Correct.
And we can waive that right and allow, if you're convicted, we can waive your right to a trial and allow the judge to make those determinations. I've advised you about that, right?
Yes, sir.
Now, do you want a jury to make a decision about the proof required for the aggravated factors if there's a conviction, or are you willing to waive your right to a trial on those matters and allow Judge Cahill to make those decisions?
I'm willing to waive it and have Judge Cahill decide those issues.
Mr. Chauvin, again, I'm going to address you individually because this is another one of the decisions you have to make for yourself. This is a waiver of your jury trial right when it comes to aggravating factors. Normally, we would submit a verdict form with interrogatories with a question and yes or no options. And that's what generally the jury would consider. In order to say yes, the jury would have to be convinced beyond a reasonable doubt. The burden of proof does not change. It's only that I'm going to be the one who's answering those yes and no questions. It was always true that based on whatever the answers are to those, that I would be the one deciding if they constitute legally substantial and compelling circumstances, and we would expect briefs from both sides on that. Do you understand that?
Yes, sir.
So basically, I will be answering those verdict form questions instead of the jury, applying the standard of proof beyond a reasonable doubt. Is that what you want to have happen?
Yes, sir.
All right. I would ask that you file a written Blakely waiver in addition.
We will, Your Honor.
All right.
I just have a question on the form that was provided, and we can, again, it's an administrative question.
Right. It's an administrative memorialization, so you can do that off the record. All right. Counsel, I'm going to talk with basically give instructions to the alternates. Give me 20 minutes, and then why don't you come on back? All right. Otherwise, we are in recess until we hear from the jury.
Hi, everyone. I'm Nicole Wallace. It's a few minutes after 5 o'clock in the East, a few minutes after 4 o'clock in Minneapolis, where we're watching the end of closing arguments. The jury in the murder trial of Derek Chauvin now has the case. Watching along with us, NBC News correspondent Shaquille Brewster, live for us in Minneapolis. Michelle Senders with us. Claire McCaskill still here, as is Michael Eric Dyson. Let me start with you, Claire McCaskill, and I'll get to Maxine Waters in a second. But on this rebuttal that the prosecution made to the defense's closing argument, he really seemed to crystallize what we've all